today we have two arguments, one in the morning and one in the afternoon. The morning argument
is a contingent issue. If, in fact, the Supreme Court holds the individual mandate that was argued yesterday unconstitutional, the next question is, how much of the, can you hear me? Can you still hear me?
Yep.
How much of the rest of the law can stand or fall? The lower court, the 11th Circuit in Atlanta, said that the individual mandate goes, but everything else stays, including the provisions requiring what they call guaranteed issue, which means everyone gets health insurance if they want it, and community rating, the provision that bars surcharges for pre-existing conditions. So the government says that's not tenable if there is not near universal participation through the mandate. The other two provisions, community rating and guaranteed issue, are not financially feasible. So the government says if the mandate goes, those two extremely popular provisions of the law have to go also. The 26 states and private parties that are challenging the law go further. They say if the individual mandate goes, the entire Affordable Care Act has to come crashing to the ground and the whole thing should be thrown out. So that is the subject of 90 minutes of argument in the morning, starting at 10 a.m. In the afternoon, there is one last question for which there'll be 60 minutes of argument, and that has to do with something of interest to the states alone and not the private parties, and that is whether the expansion of Medicaid, the government health insurance program for low-income Americans, whether the expansion of Medicaid is constitutional. These states argue that by expanding Medicaid, it will increase their own costs, and they say that the federal government can't impose such a burden on them. No lower court has agreed. They've all said that Medicaid is a state-federal partnership, and if the states don't like the conditions of getting federal money, which pays for the vast majority of the program, then they can withdraw from it entirely.
Now, we just were talking earlier about Justice Kennedy's questioning yesterday on this issue of the personal mandate. Is there any indication that, I would love to get your interpretation of what you think he's thinking and a possibility that he could change his mind or he's open to that at this point?
Well, you know, some justices, in fact, most justices, tend to telegraph where they're coming from on issues through the way they ask questions. And in fact, the questions they ask are often veiled ways of trying to influence their colleagues as opposed to trying to get information from the advocates appearing before the court. Justice Kennedy is different. Justice Kennedy's questions tend to reflect things he's really mulling over, things that are really open issues on his mind. And he is perhaps the hardest justice to read from the tone of his questions. So when he asks the government about what they call the limiting principle, and how far can you go, when he says, doesn't this change the relationship between Americans and the government, those seem to be genuine questions that are on his mind, and things that, should he answer them, this is really a radical change and there's no precedent for it and there's no justification for it, that leads him certainly to want to strike down the mandate. But as you mentioned later in the argument, he also acknowledged that the actuarial reality of the healthcare industry does take account of the impact of uninsured people on health costs, and that this market is not exactly like all other markets, and that is something that the government might legitimately seek to address. So he seemed open to considering the government's arguments as well, and that came late in the argument, towards the end of the 2 hours yesterday. So I would have to say that while occasionally we will go out on a limb and try to call the outcome of a case based on what the justices say at oral argument, this one remains too close to call.